The information provided on this live Q&A does not and is not intended to constitute legal advice. Instead, all information, content, and materials available in this live Q&A are for general informational purposes only. Information on this live Q&A may not constitute the most up-to-date legal or other information. Viewers of this live Q&A should contact an attorney to obtain advice with respect to any particular legal issue. No listener, user, or browser of this site should act or refrain from acting on the basis of the information on this live Q&A without first seeking legal advice from counsel in the relevant jurisdiction. Only an individual attorney can provide assurances that the information contained herein and your interpretation of it is applicable or appropriate to your particular situation. Use of and access to this live Q&A and any particular links or resources contained within the site does not create a attorney-client relationship between the listener, user, or browser and website authors, contributors, contributing law firms, committee members, and or their respective employers. The views expressed at or through this live Q&A are those of the individual inquirer and the individual capacities of the law offices of Erin Morse. All liability with respect to actions taken or not taken based on the content of this live Q&A are hereby expressly disclaimed. The content on this posting is provided as is. No representations are made that the content is error-free.
That's amazing that you came up with that just off the cuff.
Thank you so much.
Really good.
All right, ladies and gentlemen, welcome to our live Q&A brought to you by the law offices of Erin Morse. I am Patricio, and as you can see right in front of you, we are joined by attorney Erin Morse. How you doing today?
So good. Let me know if y'all can't hear me, because I think we fixed our mic problem. I'm trying to project my voice. Anybody who knows me in real life and not just on Facebook, you know that I typically speak pretty loud, so not hearing me was a shocker to a lot of people.
Oh yeah, no, I was that one falls directly on me. My sincerest apologies to all the listeners of that day. I failed you. Erin did not. Erin,
it happens. It happens.
But this has been a crazy. I would say since the last time we did our Q&A, a lot has happened.
Yeah.
And a lot has escalated throughout the world. And you know what I'm talking about.
Oh, the coronavirus.
The coronavirus. What are your takes on it right now?
My personal opinion is I really do my best to follow the advice of physicians and the professionals best suited to make these decisions and give us advice. You know, take the precautions that you should be taking. Concern yourself with your immunocompromised family members or yourself, asthma, etc. At this time, I don't have an incredible worry or concern about it, but the good news is that we can conduct our firm completely remote, and I can handle people's divorces when I never meet them. I've handled a number of divorces when I've never met the parties, especially where they agreed and we didn't have to attend court or uncontested dissolutions. This is especially relevant with military persons.
Oh, yeah.
So, you know, where they are a resident of Florida, but they're stationed overseas. Their divorce would still be here in Florida because that's where their home state is, that's where they were married, etc. So I had the opportunity to represent a few people who I never met. Great people, wonderful. I was able to get their divorce done. Further than that, a lot of times we can have telephonic appearances. Parties often live across state lines. We're a transient state. So we're capable of handling your entire case.
Oh yeah, we have the technology to divorce you.
Yeah, to divorce you remotely, right? So, you know, it's not going to slow us down at all, and it shouldn't slow you down from seeking your divorce, for sure.
And not only just for military itself, but I feel like majority of our clientele work their 9 to 5.
Yeah.
And you know, we work within business hours, so sometimes it's tough for you to find a babysitter, for you to get time off and not get in trouble.
Right.
So being able to do everything remotely, whether it's via phone, email, text message, I mean, we use a lot of technology to assist our clients.
Right, including programs where you can sign many of your documents right from your smartphone. So.
No, and in regards to the topic from earlier, the coronavirus. I'm taking my precautions. We've stocked up on our hand sanitizers, our wipes. I don't understand why toilet paper is going crazy. That's the one thing that has me concerned.
I don't know. I use soap on a regular basis,
Like
so I
a normal human being.
had a stock of it, right? I probably could get through a few months of washing my hands regularly and frequently. So that wasn't something I ran to the store for. Same with cleaning products and paper towels and toilet paper. I try to make my life as convenient as possible.
Yeah.
So I have toilet paper and soap and a lot of those products on auto delivery.
Oh, nice.
So Amazon just auto delivers my preferred items monthly, so I'm good.
I'm not going to lie, this morning, actually, no, I saw it last night, Tom Hanks getting the coronavirus.
Oh, that one went right to the heart.
It did.
I felt that. You can't do that to Woody. So
He can. I thought about Woody, I thought about Forrest Gump. Oh my God, who else? I think those are like of course he's done so many works.
I know.
But Woody and Forrest Gump just stick out right there. But are you ready to dive into the Q&A?
Yeah, let's get to it.
Awesome. We got a lot of questions from throughout Central Florida, our texting service, and through our emails. So
Texting service has been lit.
it has been. I freaking love it.
It's right to our regular phone number, so you're still welcome to text right to that number. We all receive it here in the office, and that does remain confidential. If you don't want to be commenting on this page and letting maybe your spouse know, who is your spouse on Facebook, that you have a question about your divorce, or your significant other, if you have a question about a paternity action, anything like that, or even, your ex-baby daddy who you kind of get along with, but you want to take him back to court for child support, you don't want him seeing that Facebook post, go ahead and text message us
at 407-900-7451, or if you want to check out our website, go to morse-firm.com. There you'll see all the fields of family law that we do, along with contact information. And if you want to set up a consultation, you can fill out our form to give us a little bit of your information, and our office will get back to you as quickly as possible so we can set you up an appointment with the attorney. Our first question comes from, let's see right here, from Sarah in Melbourne, if you want to read that one.
Okay. My child's father is traveling to Europe and wants her to accompany him. I do not want my daughter to go. What can I do? So this question is a really good one, especially in the wake of the coronavirus. So I think that's why this one came out. And the answer to this right now, obviously, is President Trump has put a ban on international travel. So at least for 30 days, right? At least that's what's the most recent news. There's no traveling internationally. So I suppose, Sarah, your problem is solved for 30 days. However, if you have a concern about corona and something like that, you're going to first need to go look to your parenting plan. If you don't have one, call me so you can get one, right? But look to your parenting plan. Is international travel even allowed? Is it something that the two of you agreed on? Does she have a passport? Who has the passport? Further than that, you'll have to file a motion. Now, you may think that this is an emergency because the issue is emergent to you, but our courts consider emergencies life or limb situations. And I understand that the coronavirus may feel like it's life-threatening, but it isn't life-threatening to your daughter unless she is immunocompromised. So, like with many of these, it depends, right? That's my favorite. It depends. It depends on if she's immunocompromised. Yeah, you want to file an emergency motion. If she's not, file a motion. And if you ask for it the right way, maybe we can get you some expedited hearing time. There are a couple of tactics that we can take to seek some court remedy quicker than that. The other approach is be a good co-parent and talk to him. Tell him your concerns. Tell him what you think, your fears, accommodate something. Why don't you try to maybe put forth some kind of remedy to be kind and accommodating when it comes to this issue. That should be an overriding concept. So if when you have an issue like this and you have a co-parenting relationship, if your first jump is to go to an attorney, maybe rethink that. Maybe your first attempt should be communicating with the father of your child. So try that first, and then if you can't, let us know. You'll have to file a motion to stop him if his parenting plan allows it.
So would you recommend that be in a written format, like an email or a text message, or would a call suffice?
A call would suffice, and probably having a conversation with him would be the most important. don't do it in, is it your daughter?
I believe.
Your child. Yeah, your daughter. Don't let your daughter hear this conversation. She doesn't deserve to be in the middle of your, dispute, or she doesn't deserve to feel like her parents are fighting over her. Children internalize that and think it's their fault. So don't give that to your child, right? That's a gift they don't want. So what you should do is meet with him, or your best solution, if you guys are able to, if the two of you could go to a coffee shop and actually sit down and have a conversation. That would be your ideal. Face-to-face is always going to go better than a text message going, "You're a moron, why would you travel to Europe?" Right? Because when a judge reads that, know that every time you put something in writing, a judge could be reading it.
No, amazing advice right there on that question. We say thank you to Sarah. Our next one comes from Griffin in Lake Eola Heights, and his question is, go ahead.
Okay. I'm an artist who has created nude self-portraits.
Ooh.
My wife has asked for all my artwork in the petition. If she wins and displays it, meaning the nude photos, could it be considered revenge porn?
Oh, wow.
So my first thought on this is, unsolicited dick pics are not art. So don't send them. Let's try to change that as a happening that occurs with people. But so this is complicated, right? It's a great question.
It really is.
So if you created nude self-portraits, and maybe there's something that you typically do, you're an artist. If you created nude self-portraits and you're just a creep, you just take pictures of yourself naked and hang them in your house, I think that you could file some kind of motion or ask the court to prevent that. There are a number of things that you could do. First, you could ask the court in your divorce, once you take it to trial, or a motion in limine or something like that, ask that the court not allow those to be released and not allow those to be awarded to her. I think the most reasonable thing a court could do is say, you can't have the tasteful dick pics that he made.
Is there such thing as a tasteful dick pic?
He thinks so.
A nice faded background.
Yeah, I mean, it's blurred lines. And you put on that portrait mode on iPhones, so it looks more classy. But there really are, right? Of course, there are many ways and reasons that this is appropriate. I think if Henry Cavill had nude pics, those are real tasteful. But back to this as an issue, I think that any decent attorney would do what they could and everything in their power to keep those on your side of the equitable distribution worksheet, okay? Keep those for you. And that would be a very reasonable response for the court to have to this issue. So I think maybe the judge wouldn't award them, but maybe they would. What if you are a world-renowned artist? I represented a world-renowned artist. He was exceptional at what he did. His art was exceptionally exquisite and valuable, and some of the art did get awarded to the wife. Actually, it was part of their agreement, right? It was the one thing that she really wanted. So in that case, she still did not get the copyright. Now, I'm not a copyright lawyer, so I don't intend to know that, but I know a little bit, right? She doesn't get his copyrights. And if he has derivative forms of that work, then he keeps those copyrights. So photographs of it he can use in other iterations. It could be on the cover of a book or something like that. Back to, could it be considered revenge porn? Well, revenge porn is really specific and is a very serious crime, right? But usually it's when you upload nude pics that someone sent to you to Pornhub.
Yeah, I mean, make them public.
I've heard that's a website. I don't know personally. But when you upload them to a porn website and you're using it to make money or using it to shame them, or you send it to all their friends or an email blast, that's your example of revenge porn. Your tasteful artwork of, nude photos, again, the fight is keep those on the husband's side, right? But those being tasteful art, if you've displayed them in an art display, the court's going to be like, you put them on display, right? It'd be just like if you filmed a pornographic movie and you uploaded it, the fact that she shared the link wouldn't be revenge porn. You made it public.
Yeah.
So, again, it depends.
Case by case. Thank you so much for that question right there, Griffin. And our next question comes from Gloria in Kissimmee. And we had to blur that one out. Go ahead and read the question.
My kid's father hasn't done shit for my 2 daughters. No child support, no visits, no nothing. Can I terminate his parental rights? Now, no. Not with just that information, right? So typically the court won't terminate parental rights on a father just because he's not really that great of a father. That's not illegal. It's not illegal to be a deadbeat. And on the reverse of that, if you are a dad who didn't know about a child and then all of a sudden you got a DOR letter and you wanted to be released from child support, no, you can't terminate your parental rights because you just don't want him. Generally, where terminating parental rights could come in Florida is when you have another parent to step in for that adoption. So Florida has a vested interest in children having 2 parents that could support them. Really, their vested interest is that it's the best for the child to have 2 parents, but I think the underlying issue is more financial, right? Why should this parent be on welfare or food stamps, etc., when another parent could be supporting the child that they made? So the moral of this story is don't make children you don't want.
Amen.
We all know how they happen. And if you don't, let me know. I will give you the lowdown on that.
Awesome. Yeah, and if you have any more questions on that, go ahead and give us a call at 407-900-7451 or check out our website.
I'm just kidding. Don't call me on how babies are made.
Morse-firm.com. Our next question comes from, from Orlando, and I can't read it. Can you read that? That was me. I'm sorry.
Lennar from Oviedo?
Yes.
Yeah. So, wife and I both signed the marital settlement agreement without too much thought. Can we resubmit if we both agree? Now, I don't know what you mean by resubmit. Do you mean that you have a new marital settlement agreement that you would like to be bound by? The answer to that is yes, especially where the 2 of you agree. If the 2 of you agree, get it ratified by a court order, final judgment, etc., yes, you can do that. The problem comes is when you sign a marital settlement agreement and you bought one for $500, those $500 divorce signs that you see when you're at an intersection. A sign that's handwritten at an intersection isn't really where you should trust divorce information. But you'll make your decisions. It's okay. And if you do that, can you call me because they're really expensive to fix, and I'm happy to help. But there are some things that can't be fixed. Typically, items in marital settlement agreements. So the moral of this story should be: don't enter into a marital settlement agreement without giving it thought or without knowing what the legal ramifications or how it's enforceable. That's your big picture, is enforcing it, is making sure that the things happen. Even if the 2 of you agree, no problem. I promise that I'll help you out. I promise I'll do more. Unless it's on paper and we have a way to enforce it, and marital settlement agreements are very specific on how you enforce them. Some of it can't be done by contempt unless you have specific provisions. So again, I understand that it sounds very appealing to have a quick and dirty marital settlement agreement or a $500 divorce, but the reason why they're so inexpensive is because the legal ramifications of how to deal with it later when they don't do what they're supposed to do, that becomes very costly.
Thank you so much. We are actually getting a question from our texting service. Let me just move this right here. I love using this computer. I'm not a fan of Apple, but the MacBook is actually doing it for me right now.
Yeah, I'm Team Mac.
The texting service says, what if a spouse violates anything in the standing temporary order of dissolution of marriage?
So that's kind of specific to certain localities, and certain counties and certain circuits have standing orders which say you can do something, you can't do something, you have to go to mediation, a number of things. So it's important to know what those standing order says. So if they violate this standing temporary order for dissolution of marriage, I'm going to speak to Orange County because that's where I work the most out of, although I practice in the surrounding counties as well. That standing temporary order here in Orange County says that you can't do anything outside of the status quo. Like you can't move 50 miles, you can't stop paying the bills because you feel like it, things like that. So it's like a freeze frame. right? So once you file, the court is really it has a standing order that says freeze. do what you've been doing. Don't do anything unless you have agreement or court order to do so. So with that in mind, that's one of the few things that you can bring in front of a judge as an evidentiary hearing before mediation in Orange County. Orange County has a standing order that also requires mediation before you can get substantive issues in front of the judge, unless you're enforcing the standing temporary order for that reason.
What are substantive issues? Just to clarify for our listeners.
Alimony, child support,
Okay.
time sharing, equitable distribution, dissipation of assets, stuff like that, stuff that you would need testimony for.
Okay.
So there's a lot of things going on here.
Thank you, texting service, for that question. Our next one comes from Hank in Orlando, and I just sent you. There you go. Do you want to read that one?
Yeah. So Hank asks, filed for custody. Mother replied but didn't reply with the right paperwork. Can I still file for default?
Ooh.
I don't. Maybe. Probably not, because filing some kind of responsive pleading, and it might matter what she didn't file for the paperwork. So what she didn't file right for the paperwork. Now, I would recommend taking a different tactic that I often use. I don't particularly prefer to let my opponents know I use this tactic, but when people's pleadings are deficient, I don't tell them. That's a dirty trick. I get it. But I typically raise it to the judge once I get to trial.
Okay.
Because once we get to trial, you can't go back and fix it. Now, the court's forgiving, and they do their best to be understanding of people without attorneys and things like that. But this is why understanding what belongs in the pleadings is so important. I've had a number of cases where I just ask for a judgment based on what was filed, and that has a specific term and rules of procedure. But I ask for the judge to make a ruling that they can or can't speak up about a certain issue or a matter, or maybe they can't have their case heard at all because that's not a pleading, right? So for that reason, I wouldn't file for a default because the judge will deny the default, and what you do is you end up outlining in this instance, right? Not always, but in this particular instance, I wouldn't file for default on that, because then you outline how it's deficient, and that gives the other person the opportunity to fix it. So that's just you going, here's your mistake if you don't mind fixing it. Now, if it's a colleague that works well with me and is kind, I'm going to give them a call and be like, hey, this isn't done the right way, because
professional courtesy.
It's a professional courtesy, and you really don't win on defaults in family law. The only reason to go forward with a default is if the other person just isn't replying, if they aren't participating at all, right? There's no reason to not set aside a default if they're a few days late, or they didn't realize it, or they missed them, anything, right? They
Things
flaked
happen.
out. And the court accounts for that.
Mm-hmm.
So the lesson on that is don't be a dick, because the court's going to allow them to answer it if they file it the right way, if they ask for it. So the better thing to do, if you're worried about it, is move forward with the steps of the case, go all the way to your final trial, and then say, hey, look at this answer. It's deficient. That's just a paragraph of I have no idea what. And I've had that.
Thank you so much. That was Hank, right?
Yeah.
Awesome. Thank you so much for your question, Hank. And the next one comes from Anita in Tampa, and she asks, is there a way to get sole custody of a child if a father has been deported without the father needing to be involved? Ooh, okay.
So, again, that depends. Were you guys married? If you were married, he already has equal rights even though he's outside of the country. He still has a right to his child. Has a paternity parenting plan already been established? If so, you'll have to undo that. But what you'll have to do is you'll have to search for him and tell the court that you looked for him, file the paperwork, try to serve him, try to find him, and tell the court he disappeared, he was deported, you don't know how to contact him, you don't know where he is, but and follow the proper steps. and ask that a default be entered against him, right? And then move forward.
Now,
and there's no real such thing as sole custody, but that's a song and dance for another time.
Now, let's say, for example, Dad got deported to Nicaragua. In regards to doing your due diligence, like, what would need to be done to, like, try and serve him? Like, attempting to serve him?
So I would reach out to someone local in Nicaragua and see if there's a process server there and see if they can find him. If you can show all the ways that are required in your due diligence.
Yeah.
You know, I looked on Facebook, I looked here, I tried to text him, I tried to WhatsApp him, right? That's how people can communicate without additional cost across
the world.
Across the world.
Yeah.
You know, try. And do you really need sole custody if he's in Nicaragua?
I think it's like kind of a given right there, isn't it?
Right, like what's he gonna do? You know, or,
I mean, especially the fact if he got deported. I mean,
what is he gonna do? Hold you in contempt from Nicaragua?
I don't think that's gonna happen.
You know, and I again, like, it depends on what you're looking for. So if you came in and these set of facts were in front of me, I probably would be like, well, what are you trying to do? What do you need? If you need to modify something, let's modify with some other resource. But if you just need to, I don't know, get a passport, I can file a motion to get that done, right? If you need something like to enroll them in school and they're giving you some barrier, I can get you a motion for that kind of shit. So, I mean, again, it depends on what you're looking for. But if he's in Nicaragua, is it necessary?
Not saying that, but wink, wink, nudge, nudge. Thank you so much for that question, Anita. Next one comes from William in Osceola County. And there you go, ma'am.
Okay. Can my spouse remove themselves off our co-signed rental lease without my permission during an open divorce case?
Ooh. Sounds like they're trying to be sneaky.
Right. So here, this is twofold, right? You're asking me what your landlord is willing to do. So the family court has no power over your landlord. That's a question to go ask your landlord. I don't know what your lease allows people to do or if they'd be willing to do it. It doesn't sound like that's likely, but your first question should be to your landlord. Let them know, hey, we're going through divorce. This is what I'm concerned about, right? I need their finances. They typically paid the rent. But again, let's go back to that standing order in many counties. Not every county has it, but quite a few do, where, you know, you're at a freeze frame, right? So don't do anything that would change. Now, that becomes more difficult when the mere virtue of sometimes how long divorces take requires that you need to do things, right? Your car completely breaks down and you need to buy a new one. Well, obviously the status quo is not you buying a new car, but you need one. Yeah, of course you can do that. The court's not like, oh, you should just not live until we say so. That's just not a sensible, right? So make reasonable decisions. Now, I should preface that with a lot of people are not reasonable when they're going through a divorce.
It's a tough situation.
Yeah, it is. And people's emotions get in the way of them. So your first place to answer that question for yourself is to go talk to your landlord or your leasing agency or whatever it is. And then second from that, no, they really shouldn't, and the standing order says that they shouldn't. But if your lease is up, why would the two of you sign another lease if you're divorcing each other?
That's asinine.
Right? If the two of you agree that it is time to go your separate ways, you know, maybe find some way to see if your real estate agent or landlord will let you out of the lease or whatever. So those are again, questions that have to go to the leasing agency, but the law says you shouldn't. You can't do that. So
thank you so much for that question. Next one comes from Peter in Seminole County, and Peter asks, will a petition to establish paternity conflict with an application for child support?
So it depends. I feel like I need like a little sign.
It depends.
Like this.
And the reason why she says that is because each case is different. Just because one law or one style, one approach can be put on one case doesn't mean that it can be put to another. Right. Each case is different. It's a case-by-case basis.
And the good news is the practice of law is called the practice because each attorney handles it different. They have different approaches that you can take. So like I said, before filing that default or letting it go all the way to to final hearing. It's a stylistic preference, right? There may be some instances where you could have filed that default. They don't know how to cure it, and for that reason, it could be defaulted, right? It's not my preference based on the very limited facts that I have, but it just depends on what your goals are and what your ultimate goals, and a lot of times the practice or what I'm doing is I give my clients, hey, we have 3 options on how we can handle this. This is what I think the likely result will be.
You give a game plan.
Exactly, and we get to decide it together. So you really get to own your case. And if you don't feel like you own your case, or your attorney just does anything they want or aren't keeping you informed, maybe ask more questions, become more involved. This is your case, right?
It's your money. It's your life on the line. You have every right to get the answers you need from your attorney.
You're right. And there are a lot of strategies behind a lot of my suggestions, and they're based on me making assumptions on certain facts. So in this case, I'm going to assume that an application for child support is with the Department of Revenue, okay, and not maybe a petition for just child support. And a petition to establish paternity doesn't conflict, but instead runs concurrently with a Department of Revenue request for child support. So the Department of Revenue can continue on their child support course. And again, how you correspond with the Department of Revenue is really going to gauge how this gets done. So the first time you get that letter, I really do suggest reading it and bringing it to an attorney just to get some advice on what it is and what your goals are with your litigation or what you need for your child. So a petition to establish paternity can typically, once you get your petition to establish paternity, that's where you get time sharing and parental responsibility. Child support is exclusive to child support. So your petition to establish paternity will run concurrently at the same time as a Department of Revenue. And you will notice them as related cases and make sure that you have corresponding court jurisdiction and coordination of litigation in both of these things. So you'll want to make sure that you could seek a superseding order at the time of a Department of Revenue hearing. Another valuable thing about having your petition for paternity at the same time as the Department of Revenue, or making sure that you start on that process at the same time, is that arrearage support.
Oh.
There are times where you could ask that arrearage support be dealt with in your paternity case and not in the Department of Revenue. Now, I'm not saying that there aren't arguments from the Department of Revenue against that. There are. But if you're kind and you work with them, honestly, I think it's mostly when you have an attorney. I know the DOR attorneys. They are good people. I know a lot of you may not have that experience, but they are reasonable. I've had great success working with them and being honest with them and making sure that, but that's because I cooperate with them. I come to the hearing, I come with the documentation, I present a position of honesty, I let them know about our paternity case, and I say, hey, listen, we're just trying to get this right. If it's easy for you, how about we come to an agreement that looks good for both of us, and you don't even have to go in front of that judge. We walk it in, the judge signs off on it, and we can get some terms that are a little bit more favorable, or make sure you get credit for the child support you did pay. Speaking of which, don't pay child support unless you have a receipt.
Amen. And it's funny that we were talking about DOR because our next question kind of relates to it. And there we go. I just had it right now. Boom, boom, boom. Andrea from Winter Park asks, would I get better or fast results if I hire an attorney or let Florida DOR handle my child support case? Oh, man.
So we actually have an interesting case with this, and it's happened a few times where I cannot hold someone in contempt for non-payment of child support as a private attorney, which has different resources and different powers of contempt in the civil court if the Department of Revenue continues to represent your interest related only to the collection of child support. So again, it depends on your goal. The Department of Revenue will get you your child support order faster. That's true. But they don't always get it accurate. because they're working on volume and they're just trying to make sure that child support is as best as they can do.
Oh, wow.
Right? And I don't stand here to judge the Department of Revenue. They're doing the best that they can. They have a lot to handle. It's a government-based entity. They have good attorneys who are there. I have nothing bad to say about that. But you'll get child support. However, holding him in contempt or pushing your case forward and having more control over your case is what will happen with a private attorney. Now, again, you get what you pay for. The Department of Revenue, the reason of that is the Department of Revenue actually represents the state of Florida on your behalf, right? Because the state of Florida would rather not have food stamps and cash assistance if dad could just fucking participate, right? If dad could be doing his part, and that's really their point. So they really represent the interests of the state of Florida, not you, even though they work on your behalf. I understand that doesn't seem clear, but there isn't more way to explain it.
Well, I think what they're trying to say is will they get better attention if they hire a private attorney than to get public? I don't want to say public assistance, but
it's what it is.
State appointed attorney.
Right, and again, you get what you pay for. A private attorney is going to be more expensive, but you get to have more control over your case, over these things I want, this is what I don't want, I don't think this credit should be there. But bear in mind that if you do a paternity case, the court has to address time sharing. So again, it's what your goals are. If you just need to get some child support, or they required you to do it, the DOR is perfectly acceptable. But you should be prepared that if you file for the Department of Revenue, the father of your child, the father of your child will likely file a paternity action thereafter. So, deal with it one way or another.
Thank you so much for that question. Our next one comes from Mary in Castleberry, and she asks, oh man, is it illegal not to tell the baby's father the unborn child's gender? Wow. I don't know if someone's being petty or just... Erin, go ahead. I'm sorry.
You sound petty. No, of course not. Some people don't ever find out the gender of their child until the child's born, and some people choose to gender non-conform. So I don't think that there's any set of circumstances where you not telling the baby's father your unborn child's gender. And as we know, because you all listen to me so diligently, an unwed father does not have any rights to the child until he goes to court to get them. I don't care if he's on the child support.
Birth certificate.
Birth certificate. I also don't care if he's on child support, because he has no rights to the child, only the right to pay once you put him on Department of Revenue child support. So, no, it's not illegal to do any of it. It's not really going to be relevant to anything, anywhere. No one cares.
I think we just got a question. Where did it go? If I'm pregnant, can I request child support if I was abandoned?
Yes.
Really?
Mm-hmm.
Oh, wow. I didn't know that one.
So you typically, what happens is you go there to the Department of Revenue,
mm-hmm.
you file. By the time they get through the process of the paperwork, it's why they let you start, they will, your baby will be born.
Oh my goodness.
So they're not that quick.
Yeah.
Right? You're probably not going to file for child support the day you pee on a stick. Because that doesn't make sense. But they will. Or you're probably better suited to go to Department of Revenue after the child is born, because you can recover birth-related medical expenses. So uncovered birth-related medical expenses are really, at that time, because you'll have the receipts, and of course you'll be diligent in keeping those receipts. You'll have the receipts and you'll be able to recover those as well. So even though you can, that they will probably let you start the paperwork. I could file a petition for paternity. You should wait until the baby's born so you have those uncovered medical costs that you could seek reimbursement from.
Thank you so much, Facebook, for that question. Next one is There you go, Erin. Go ahead.
Is this Erica from Daytona Beach?
Yes.
All right. Child support ends on my son's 18th birthday. He's still in high school. Can I kick him out? He doesn't obey any house rules. Well, I hope that the reason you're kicking your son out is not just because he's now no longer a financial benefit to you. Yes, at 18, he's an adult. You can kick him out. There's no law against that.
Would she have to evict him if he is if he lives there?
That'd be a landlord-tenant question, and maybe. But if I mean, how does he not obey the rules? Is he like not do the dishes enough, or I mean, do you need to call the cops because it's unsafe? None of us can stand here to say that hasn't ever happened in families where there's domestic violence. So yeah, you can kick him out, and if I were you, I would just be stern that his stay has ended and really talk to him. Hopefully this doesn't sever your family, and hopefully you have a better way to repair family relations in this situation. I always hope for happy family unity, but sometimes that doesn't work. People's lives are more complicated than that.
Oh yeah.
Once he's 18, he's got to go.
He's got to go. And by 18, you should have your life together and be ready to move out, because I'm sorry, the second I turned 18 in November, and the second I graduated high school, I had everything ready to go. I had my U-Haul ready. I was ready to go to college, because I went to college in Colorado, and I felt like the adult right there. I'm like, I'm 18, I can do what I want. Boom, I'm out. And yeah, I was ready to leave the nest.
I mean, I know a lot of 25-year-olds that probably still need their mom's guidance.
Ooh.
I'm like,
yeah.
You could use a parent. So I don't know. Every family is different, right? And it really depends on what your family circumstances are. So as we know, it depends.
It depends. Thank you so much for that question. Our next one comes from Vince in Orlando, and he asks,
can I take my daughter out of state while her mother is in a coma from a car accident?
Wow.
So it depends. I gotta get the stick. Do you guys have a parenting plan? If you have a parenting plan, file something with the court. I would urge you to put those facts in front of the court, because if at some point she wakes up from her coma from a car accident to find that her daughter is in Oregon, I think that you'll be in a very disadvantaged situation and you will have violated certain court orders. If you're going on a vacation, that's probably not a problem, right? I assume you have all of the time sharing at this time. And again, it's probably not a problem to go on vacation.
Mm-hmm.
But if you're going to move out of state, you still need to file your petition for relocation.
Would, let's say, for example, said individual, there is no parenting plan, there's nothing established, and she goes into the coma, would it be considered kidnapping if you took the daughter?
You have no rights to your child until you go to court to assert them.
There you go.
So since you don't have the rights to do that, it would be. Now, again, a parent would have to claim them as missing, but grandparents could do that if you didn't typically have time sharing with the child. So my suggestion would be to establish your paternity, and because she's in a coma, again, go to the court, get your court order, protect yourself. There's no reason that if she were to wake up in 3 days and you pulled some shit, that the court wouldn't come down on you for that, and you would have some adverse consequences. So do it right, because you don't want findings in this court, catalog of nonsense to show that you're the non-cooperative, non-compliant, cowboy parent, because that sucks.
Yeah. I mean, does it really take a coma for you to be able to take your kid? I'm sorry.
Yeah, right.
Thank you so much. And our next one comes from Alice in St. Cloud. And Alice asks, we have another censored one. I have a teen out effing control. I am fearful for my life. Can I give up my parental rights and have the state take over? Ooh.
So there was a story that I read on the news once. I don't remember what state it was in. Don't quote me on this either. Where he had some 6 kids, and most states, including this one, had that safe haven law where if you have a baby, you could drop them off at a hospital or a fire station or some other location designated as a safe haven for infants, no questions asked.
Mm-hmm.
He dropped off all 6 of his kids. Obviously, they weren't infants.
Oh my God.
But the law didn't clarify, I believe, in this particular state because of this story. They changed the law, right? At the fire station, it was like, I can't take care of these kids anymore, okay? That's fucked up.
That is fucked up.
But I don't think that the court will take kindly to you doing that. You can't just go to the state and say, take this one, right? This one is a dud, right? It's kind of a no return policy, especially once they become teenagers. So the unfortunate reality is what will end up happening is you probably got to do some things, right? How are they out of control? Do they need to be Baker Acted? Do they need a Scared Straight program? Do they need to be Marchman Acted? Do you need, what? Try a little bit more. I know that this is a hard truth, but I'm about that.
Yeah.
Try a little harder. I know that's
assert yourself.
It's a human being, right? And that you can't just return it to the store because it doesn't work properly. Maybe you have to kind of work with it a little bit harder, exhaust your resources. If I'm sorry you're going through this. That's really oftentimes what I have to say, is that life is imperfect. And how out of control are they? Are they breaking the law? Do you need to call the police and say, he's stealing or doing drugs or, doing other things that are illegal, and you maybe need the police's help? So again, search for your resources. This would be worth talking to a lawyer to, but it's a no return policy on kids. Sorry, and some of them suck.
Yeah. Each case by case basis. Thank you so much for your question. And I think our last one is actually coming in from the texting service. Oh, all right. You ready for this one, Erin?
Yeah.
How to appeal a divorce. My husband filed a dissolution. A judge signed it, but I don't want a divorce. Wow. Let me read that one again. How to appeal a divorce. My husband filed a dissolution. A judge signed it, but I don't want a divorce. Wow.
So is the basis for your appeal that you want to be married to him? Because the courts, even if, again, I'm going to make a few assumptions here that you didn't answer and you didn't participate in this divorce, which was a mistake.
Yeah.
And of course it got granted because you were non-responsive. That's one of the very good reasons that we have defaults, so that they can get their divorce. In general, a court won't stop someone's ability to seek and achieve a divorce because you have the right to divorce someone. You could delay it, but so that's not a reason that you don't want a divorce. Also, as a human being, I want to give you some advice, like a person to person that is outside of the scope of the law. If someone doesn't want to be married to you, let them go. Because undoing the divorce probably isn't going to make him go, now I want to be married to you. Well, since you appealed it, I'll come home. That's not a very loving relationship, and truly you deserve better.
I think of the movie, He's Just Not That Into You.
Yeah. But again, if you think that you could win him back and your relationship isn't over, that is an analysis for counseling. That's talk to him. Maybe you could bring him flowers. And you guys could always get remarried. As you know, it's very easy to get married and a bit more difficult to be unmarried. So I think that appealing your divorce under this set of circumstances is not going to go anywhere, right? I didn't want it is not a basis for an appeal. there are other reasons that there could be a basis for an appeal or a reconsideration or a number of other resources because certain things were missed or are insufficient or deficient under the law. And that's, again, a question where we'd have to see that final signed divorce to know that. But if you just want your husband back, your appeal is probably not the way to go. Also, it's very expensive to do that.
Yeah. I mean, also, in the criminal field, appeals are extremely expensive. So I can't even imagine how it is in the family field.
It's worse because the issues are just more, I don't know.
They're more petty.
Yeah, in some instances. So if you went to the judge and at the time of the final hearing you just said, I don't want a divorce, it may delay the proceedings, but
you can't force someone to be married to you.
No. And do you really want to?
No. If they don't love you, you're wasting your time.
There's a lot of people in the world. Not that many have coronavirus.
So true. But once again, we say thank you to all the viewers, everyone who threw in their questions. Remember, if you have any questions for the attorney, we're going to be doing another live Q&A next week. If you want to remain anonymous, you can send them to our email, which is admin, ADMIN, at morse-firm.com. Even if you want to be even more anonymous, you can send them through our texting service at 407-900-7451. If you would like to set up a consultation, go to morse-firm.com. Send us your information. One of our reps will give you a call to get more information and set you up the consultation with the attorney. Also, give us a call at 407-900-7451. Once again, I do have to read the disclaimer. The information provided on this live Q&A does not and is not intended to constitute legal advice. Instead, all information, content, and materials available in this live Q&A were for general informational purposes only. Information on this live Q&A may not constitute the most up-to-date legal or other information. Viewers of this live Q&A should contact an attorney to obtain advice with respect to any and all legal issues. No listener, user, or browser of this site should act or refrain from acting on the basis of the information on this live Q&A without first seeking legal advice from counsel in the relevant jurisdiction. Only an individual attorney can provide assurances that the information contained herein and your interpretation of it is applicable or appropriate to your particular situation. Use of and access to this live Q&A or the links or resources contained within the site does not create an attorney-client relationship between the listener, user, or browser and website authors, contributors, contributing law firms, or committee members and their respective employers. The views expressed or through this live Q&A are those of the individual inquirer in their individual capacities or only the law office of Erin Morse. All liability with respect to actions taken or not taken based on the contents of this live Q&A are hereby expressly disclaimed. The content on this posting is provided as is. No representations are made that the content is error-free. Join us next week. We'll be doing another one. Like I said, send us all your information, your questions. I already gave it out there, but check out morse-firm.com. Erin, do you have anything else to say?
No. Be sure to join us next week. I'll be sure to answer any questions that y'all send me. Keep coming your interesting questions too. You guys have had some really unique circumstances. So
far, the one that has stood out, and I've actually gotten questions about this one afterwards, was the livestock one from our last week's episode.
Yeah, you ain't keeping your pigs.
But once again, thank you so much for listening. Give a like and subscribe to our Facebook page. And give us a call, 407-900-7451. Go to morse-firm.com, and we'll check you all next week.